full.
Okay. Okay, Fahmi.
Okay, Assalamualaikum and very good evening to lecturers and to all my friends. Today we're going to present quite an interesting topic, which is the treatment of domestic laws in multinational corporations related to bribery and corruption. The group members for this is Law-Saiful and Fahmi. Okay, it is no secret that corruption and bribery is rampant in the corporate world. Across the globe, many corporations have offered some for payment in return for contracts or favors from government or other companies. Large MNCs are not exception, having been involved in numerous high-profile corruption scandals over the years, which is tainting their image and brand names. MNCs, especially when they have newly set up in a foreign market, are often faced with the need to secure the necessary licensing, permits, and other approvals, and may choose to offer some payment or gift to government officials to help quicken the process.
Right. So the definition of multinational corporations or MNCs. So Vanden and Wells provided the definition of MNCs as enterprises or characteristically made up of a parent firm located in one country and a cluster of affiliated firms located in a number of other countries. So generally, MNCs are further understood as firms which have internationalized through acquisition, mergers, and joint ventures, or through greenfield investments.
All right, there are a few examples of MNCs in Malaysia. Few examples such as ExxonMobil Corporation, based in Texas, Honda Motor Company, based in Japan, Nestle, based in Switzerland, and HSBC Bank, listed on the London, Hong Kong, New York, and Bermuda Stock Exchange, and have in 130 countries and territories.
All right, thanks. So the disadvantages of MNCs, one of them is the laws, which is one of the major disadvantages. It's a strict and stringent laws applicable in the country, and MNCs are subject to more laws and regulations than other companies, whereby it is seen that certain countries do not allow companies to run their operations as it has been doing in other countries, which result in a conflict within the country and results in problems in the organizations. So MNCs are responsible to host countries for their actions there. So if they have a presence in the United States, as most of the multinationals do, they are also responsible under the US law for their actions, even if they were conducted abroad. So further complicating matters, MNCs are also subject to international law. So a clear policy of the best practices and the corporate support structure are required for the sake of clarity and compliance.
In Malaysia, we have a new amended provision, which is Section 70A of the Malaysian Anti-Corruption Commission Act 2009, which applies to commercial organization. In this provision is mentioned that a commercial organization commits an offense if a person associated, the keyword, a person associated with a commercial organization corruptly agree to give, promise or offer to any person any gratification, whether for the benefit of the person or another person with intent to obtain business and or to obtain or retain advantage in the course of business for the commercial organization. Subsection 8 defines a commercial organization, a company incorporated under the Companies Act and carries on a business in Malaysia or elsewhere. Subsection B, a company wherever incorporated and carries on a business or part of business in Malaysia. It means applies to MSCs in this section.
All right. So meanwhile, in the United Kingdom or UK, they have the UK anti-bribery laws, which is UK Bribery Act 2010. So Section 7 of the UK BA on the failure of commercial organizations to prevent bribery is almost similar to our Section 17A of MACC Act 2009. So more or less the sections related to partnership and also companies are related and equivalent to the Section 17A in Malaysia.
In the United States, US, they have the Foreign Corrupt Practices Act, FCPA of 1977, which is quite the same with our Section 70A, which it targets such practice through both anti-bribery and accounting provisions. Okay.
Right. So meanwhile, in Hong Kong, they have the Prevention and Bribery Ordinance, or they call that as POBO, which is enacted in 1971, and also the primary anti-bribery legislation in Hong Kong. So it contains provisions prohibiting bribery for both public and private sectors. So Section 3 until Section 10 of POBO covers the public sector offences. Meanwhile, for private sector, they have covered under the Section 9, which includes on the gratifications and also the bribery, including the private sector. Okay.
It's a case study. It's an example of one case before the Section 70A applies, which is reported in 2015, with the Vice President of Alcatel Malaysia sentenced to 2 years in prison and fined 125,000 being committed in KL court of bribing a procurement official of Telecom Malaysia for the amount of 25,000. She was employed by Alcatel Network System Malaysia, and Alcatel Malaysia had its HQ, which was Alcatel Lucent SA, based in France. So far, there's no prosecution against MNCs in Malaysia yet with regards to corruption. But there's one company, a Malaysian company, a ship chartering company in 2020, Pristine Offshore, be charged in Sessions Court here, and then with a charge offering a bribe to ensure the company was awarded a subcontract in oil exploration work. This is the first commercial organization in the country be charged under 60A and directly impose corporate liability on commercial organization for corruption and dishonest commercial misconduct. Okay.
Right. So how MNCs could protect from being charged under the anti-bribery law? So the recommendations here are the company must prove that it had in place the adequate procedures which designed to prevent persons within the organization from undertaking such corrupt conduct, okay? So including directors, controllers, officers, and senior management as well. So in Malaysia, we have the guidelines on adequate procedures, which issued by the Prime Minister's Department on 11 December 2018. So this gap actually encompasses the adequate procedures that could be implemented by MNCs and corporate bodies across the board of directors, CEO, and also employees. So they have 5 key principles, which is known as trust, which will be explained by my colleague, Fahmi.
Trust principle meaning TRUST. First, top level commitment. R, risk assessment. U, undertake control measures. S, systematic review and monitoring and enforcement. T, training and communication.
All right. So here are the examples of MNC's policies whereby they have put in place to comply with the domestic and international laws regarding to anti-bribery and corruption. So the left one is the HSBC Bank. As you can see, it dictates whereby the HSBC shall comply with the UK Bribery Act, US Foreign Corrupt Practices Act, HK POBO, and also France Law-Saiful 2, whereby the right one is the framework and policies for prudential assurance dictates on the anti-bribery and corruption laws, whereby they need to comply with the US FCPA, UK Bribery Act, Hong Kong POBO, including the MACC as well.
In conclusion, as MNC is a subject of international law, it is established in more than one national state, which comprises a parent company in one state and another subsidiary. It can make positive or negative impact to the state in which there is MNC. And it can also violate the international law. And therefore, this comes as a timely reminder to all commercial organizations, including MNCs, to take immediate steps to comply with the adequate procedures in order to avail themselves to the statutory defense. It is important for all organizations and senior personnel within MSC to start taking stock of their existing policies and procedures to assess whether they take up to the expectation of the domestic anti-bribery laws. And if not, to seek legal advice and home expert to start building up its adequate procedures according to its legislations, which to be adhered with. All right.
All right.
That's all our presentation. Thank you to all.
All right. Thank you, everyone.